Rowan and Martin's laughing. One ring again, two rings.
James Fenimore Cooper was the name I was thinking of this morning.
Act 250, Bill Burke's office.
Yes, good morning. This is Paul LaFave, the Vice Chair of the House Committee on Natural Resources, and we're waiting to hear from Mr. Burke today.
Absolutely. Can you hold on just a second and I'll go get him.
Thank you.
Hello there, Mark, or Chair LaFave.
Thank you. Yes, Mr. Burke. We're pleased to have you with us this morning, and if you would, please proceed with your testimony.
All right. Well, what I'd like to do is answer, whatever questions that I might be helpful on. I'm not sure where the committee is at or what specific questions. I have an idea, but is there a question from the committee you'd like me to start with?
Yes, perhaps you could give us a more or less a review of on the record as opposed to de novo as on appeal.
All right. On the record presents, I think, a solution in search of a problem, meaning that the on-the-record due process requirements that the Commission would have to observe in order to create a good record, a record that the environmental court would not have to remand back to the Commission to get a better record, a record that isn't riddled with procedural boo-boos by the Commission, because on-the-record proceedings are more formal and subject to more, rules of the rules of civil procedure. So, on-the-record proceedings in front of the Commission become less citizen-friendly. They become more formal and more difficult for the citizens to participate in. They become more difficult for the commissioners to properly administer and hear. They become potentially riddled with technical legal motions filed by attorneys and so forth, motions that the Commission would be obligated to stop the proceeding and make rulings on at some point. And so, I would put on-the-record proceedings, which is in my earlier testimony I explained I had personal experience drafting the pilot program where we tried this in 2000 and 2001. And as now Judge Walsh and I sat there trying to figure out how to create a rule that would tell the commissioners how to properly handle an on-the-record proceeding, we began to understand the layers of the nuanced complexity that would be added to the Commission process, none of which would be helpful to the commissioners, none of which would be anything but chilling for citizen participation. And so I fell out of love with the on-the-record idea, which I originally was in love with because I thought it would put all the parties, the applicant in particular, it would incentivize them to put on the Cadillac version of their case in front of the commission. So I thought that would be a good thing. But then when I got into understanding the procedural complexity it would layer onto the local citizen-friendly process, I fell out of love with it and would, now characterize it, for me anyway, as a bad idea. Is that, are there any other on-the-record questions?
We heard testimony from Ed Stanek a while back, talking about coming up with a hybrid on the record at Novo. And he was suggesting, or made the suggestion, as I recall, of more or less having, I believe he was referring to someone within NRB making a determination as to whether questions on what should be admitted as evidence were correct. And if there was substantial reason and there was a petition put forward that they were not, then it would be opened up to a limited point of view as to where those errors occurred, and consequently the petitioner would get an opportunity to present that part of the case that was not heard at the district commission. And I'm wondering if you think that kind of a situation would work.
Well, of course we can make anything, ultimately work. But the question that I think Ed was referring to, and that sort of procedural thing, you got to remember that sort of guidance and rulings by the commission on what evidence is relevant and material and should be let in, what level of pre-filed testimony and so forth. The commission could get some kind of legal guidance on these questions, and all of that takes time. All of that delays the process, in my opinion, and layers onto the process at the local level a lot of potential delay and expense, because it requires a lot more pre-hearing legal type work, trying to narrow these things down. And I can tell you and the committee members that this is ordinarily not a particular problem for the commission. We routinely attempt to distinguish what my father used to say, well, I don't want to use bad words, but you know what I'm talking about. The distinction between dog waste and shinola. The commissioners are pretty good at saying this application in front of us is going to have significant impacts under 3 of the 10 criteria, and we're going to hone right in on those. The commissioners are good with that. And so that's a way that we go right out in our hearing notice and we identify those areas that we want the applicant to focus on in the hearing. So we don't ordinarily have to spend time going back and getting legal advice on what kind of statement of questions or what kind of pre-filed testimony should be allowed or not allowed, or what parts of the rules of civil procedure should be allowed to apply and which ones shouldn't. So my testimony to you today is that yes, we could do that. We could do anything you tell us to do, but that it would flunk Criterion 11 in Act 250, which is not published. But Criterion 11 is the question, is this a bad idea? And I've concluded that on the record at the commission level is a bad idea.
Thank you. Anyone else have a question here? No? Yes, Representative McCullough.
Yes. Okay, then, not to on the record. Let's go to a different, at the district commission. Let's go to the where district commissions' decisions are going to be appealed. And could you refresh our memory as to your position on that since the last time, or it may have actually, are we talking about the Enhanced Natural Resource Board? Are we talking about keeping it in the E-Court? Or are we actually, or what might you envision where those appeals would end up?
Well, thank you very much for the question. I've testified before, and I've strongly believed that the committee's original idea, the one called the verb,
Yeah.
that being an enhanced, Vermont Environmental Review Board,
Yep.
with qualified, 5 or 7 qualified, highly respected people with varied backgrounds and so on, would be the best repository for district commission appeals. And that's because that type of board can be managed, I think, in a more citizen-friendly way, for one thing, because you're not sitting there staring at a judge. Not that judges' robes are bad or any of that stuff, but you can manage that kind of an appeal as a citizen and so on. I think in a more comfortable venue. That's one thing. Item 2 on the creation of the verb would be that the members would presumably be vetted. They would be nonpartisan. Well, they'd be subject to some advice and consent of the legislature, which I think is a smart thing to do. And it would require legally the reestablishment of the Chinese wall between the governor's office and the appellate body, the new verb, which I think is necessary to reestablish the integrity so that we have the citizens know that there's a thumb on the scale somewhere in the process. I think the environmental board decision-making can be handled efficiently. I think it could be perceived as more fair and inviting to the public. I think it can result in some very sound, decisions which we can rely on for precedence at the commission level. So I would, of the options available to you, I would highly encourage you to go with the original Vermont Environmental Review Board professional board approach.
Yep.
And
so for me, in I don't know, my naivete a year ago, or just plain confusion, felt we were continuing to keep the existing NRB, which would function as it's supposed to now, but in its education and working with the district commissions. Do you see that board being dissolved and sort of merged into and becoming the verb, or even in a different version, the Enhanced Natural Resources Board?
What I think the advantage of the verb is it would be a new board. The Natural Resources Board, as it's presently constituted, I think it's accurate to say that the membership has delegated their authority to the chair. That creates a problem. Appeals aren't sent there, which destroyed the Chinese wall, creating integrity issues and so on. And so some version of an enhanced NRB strikes me as not as clean a cut, not as clean a profile with separation of powers and that sort of stuff,
Right.
as the committee's original verb idea.
Right.
So I would favor the verb. I think in either scenario, you would have to separate out at least one attorney to provide advice as necessary to the commission, and that attorney could then recuse themselves from any appeal proceedings in front of the verb.
Alrighty.
And that's entirely doable.
Yeah. That is a concern that some had, that there would be a conflict of interest as the verb hears appeals, and you think that's very separatable and doable.
I do.
Yep, thank you.
Yeah, and that would be where the verb, again, would assign an attorney to assist the commission as needed, or the coordinator, whatever. That attorney would be then recused from participating in any appellate work on the case.
Yep, thank you.
You're welcome. Thank you for the question.
Anyone else? Well, thank you very much, Mr. Burke. I appreciate your time and your replies.
Mr. Chair, may I comment on one other feature of the current version of the bill?
Certainly.
And that has to do with the idea, and I'm not sure where it came from, the idea of assigning the responsibility for issuance of jurisdictional opinions to the commission, and to take the issuance of jurisdictional opinions away from the coordinators and give that role to commissioners. And I'd like to just quickly say that also flunks criterion 11, because I can tell you that jurisdictional work is routinely black and white. In other words, the coordinators generally are able to apply the law and the rules as the statute lays them out, and provide prompt answers to the citizenry and to applicants. By prompt, I'm saying we routinely are able to issue project review sheet. Those are also jurisdictional opinions. We can do those, turn those around in a day or two in most cases. So we have, at the coordinator level, I think the concept of having jurisdictional questions answered by a committee, in other words, the commissioners, who are part-time volunteers, who are not drenched or saturated or in the law and in the rules, to ask them to be issuing all these jurisdictional opinions is another recipe to bollocks things up and introduce delay for reasons I'm completely clueless on, whoever came up with that idea and what problem they're trying to solve with that idea. So I appreciate the opportunity to provide that comment to you on that particular idea.
Thank you very much. Appreciate it.
Yes, sir. Thank you.
Good day now.